How's jail?
Not great.
Really?
Yes, sir.
Over and over and over. And you know that in the last 3 years, you and I.
12 cases in 3 years. The judge has run out of patience and compassion. He's explicitly calling out the cycle of recidivism. Picking up a case, pleading guilty for a time-served deal, getting out, and immediately committing a new crime. This is the moment the judge decides the system needs a drastic intervention. The consequence? I will not take any more deals with you ever again. That is a complete shutdown of the typical plea bargain path.
Have had 12 cases together. Never have you once appeared on your own. You pick up a new case, you plead guilty, you get out, and you pick up a new case. Over and over and over. Ms. Washington, I'm done. I will not take any more deals with you ever again. And now I'm going to set your case for trial. And if you're found guilty.
The new strategy is revealed: trial and a dual diagnosis residential facility. For repeat, low-level offenders who also struggle with substance abuse or mental health. Dual diagnosis, jail time doesn't work. The judge believes forcing a trial and a commitment to a long-term, inpatient facility is the only way to break the cycle. He's saying, the days of you pleading, getting out, and picking up a new case, it's over. This is a massive shift from punishment to mandated rehabilitation.
We will be looking at a residential facility, a dual diagnosis residential facility. I'm telling you now, the days of you picking up a case, sitting there, pleading guilty, getting out, and picking up a new case, it's over. Never again. You understand? I'm now, every single time, we'll just, I guess we'll have to set up a trial, and we will start doing the facility approach until it actually takes. But the cycle of you picking up, pleading, getting out, and picking up a new case, it's over.
You give me another chance.
Ha! Because we haven't given you 25 other chances, Ms. Washington. You've never once.
The defense is trying one last desperate appeal. I never had a ride to court. The judge, however, is focused on a pattern of non-compliance that spans 25 other chances. The plea for "just trust me" is heartbreaking but futile. The judge has to prioritize the evidence of 12 prior failures over one promise. This is the emotional drama of the courtroom, the clash between personal appeal and overwhelming legal history.
Because I never had a ride, and nobody never wanted to bring me to court, so please, Judge, please, I will never do better.
Do you really think that if I let you out now, you were actually going to come back?
I won't, I promise, Judge. Just one more chance, please. Just trust me, please. Please.
No, that time is long gone, Ms. Washington. What I'm trying to tell you is that I want this to stop happening. I want you to stop picking up cases, pleading guilty, getting out, and a week later you pick up a new case. Okay, well, that's the point. We are now done. It will not happen again. So that next time, because you won't be with us forever, but I want you to think in the back of your mind, the next time you want to make a move when you're in the free world, it's always will end up in a residential facility. You understand? Over, over. Thank you.
So what I have to do now?
We're going to set up a trial, and we'll go from there.
What trial?
You're gonna go to trial, we're gonna pick a jury.
If you're found guilty,
Guilty with what?
well, now you're with us.
Oh,
So your charges against you.
Selling $20.
I'll talk about the facts of the case.
Ms. Washington, you're charged with harassment of a public servant in your felony case.
Here are the charges: harassment of a public servant, felony, burglary of a motor vehicle, and criminal trespass. Despite the severity, the judge's focus remains entirely on non-appearance. The bond is set astronomically high, $7,503**. on a misdemeanor trespass charge, specifically because the defendant never once appeared in the previous 12 cases. The cost of a bond is now directly tied to her decades-long history of failure to show up for court.
Us, burglary of a motor vehicle and a criminal trespass.
I
I
did,
have your bond at 7503 on the trespass because you've never once appeared. And in the other 12 cases that we have, you've never once appeared. So hey, if you were the judge and you saw that person, would you give them a bond?
not Judge. How long trial is?
The defendant's confusion is stark. What trial? You don't know what trial is. This exchange underscores the defendant's detachment from the legal process she's been cycling through for years. She's been existing entirely in the plea and release bubble. Now she is being forced into the full complexity of a criminal trial. This is a dramatic escalation that she simply does not understand, reinforcing the judge's point that the cycle must be broken with new, forceful measures.
You don't know what trial is?
No.
Okay,
Like,
it's okay. And I'm gonna have Greg explain it to you so that we're all on the same page. It takes time to get evidence, but I'm gonna try to get it as fast as we can so you don't just sit there and languish.
I can tell you that I did steal a $20.
In one final critical moment, Miss Washington admits, "I can tell you that I did steal a $20. The judge immediately cuts her off. "Stop. I don't want you to talk about the case." What? Because they are headed to trial. Anything she says now is admissible against her. The judge is trying to protect the integrity of the trial process, but it's a perfect encapsulation of her problem. An immediate, impulsive admission that perfectly fits the pattern the judge is trying to stop. What do you think about the judge's new tough love approach? Will a residential facility finally work?
Stop. I don't want you to talk about the case. The only thing I want you to understand, the days of you pleading guilty, getting out and picking up a new case, it's done. That's it. All right. Ms. Washington. Thank you.
You can make your note if you want.